All right, good afternoon. It is the 16th, Monday of December, and this is the Energy and Carbon Management Commission. We will start with a roll call.
Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner Mesner,
Here.
Commissioner Oath, Commissioner Ray,
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 6 commissioners present.
Very good. Good to see everybody. We have a short agenda, but an important one today. We do have a consent agenda item. So we'll take up, or actually, does any commissioner have comments? That's number one. All right, seeing no comments, we'll take up consent agenda. Does any commissioner have questions on consent? Seeing none, I would move approval of consent. Do we have a second?
Second.
Motion and a second. Further discussion. Seeing none, all those in favor signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. We now will turn to the one docketed item on our agenda, 241-000-246, the Class 6 rulemaking. Commissioners, where we left this, and for our stakeholders who are listening in, we received a briefing last week from the Colorado Energy Office and Colorado Department of Public Health and Environment on the topic of the social cost of carbon. Following that briefing, we allowed the parties who desired to file 5 double-spaced pages of writings on the topic of social cost of carbon. Those were all due by Friday at noon. We, the commissioners, have reviewed all of the filings. We also received 2 drafts from staff on 2 different matters. One was a draft that contained, there's 4 areas that I want to talk about. One, we had asked for edits to Rule 1403. A majority of commissioners desired to make sure that scientific and monitoring wells did not have to comply with alternative location analysis, cumulative impact analysis, and Rule 50B. Those edits were made by AAG Mercer. Second, there were some slight edits to the Bruno area notice to the Southern Indian Tribe. Those edits were also made by AAG Mercer. Then staff had suggested edits to the SBP concerning the issue on the social cost of carbon. Those edits were provided to us last week. I'm informed by staff that their position remains to advocate for the edits that they provided. In other words, they looked at the filings as well, but believe that the edits that they suggested remain appropriate for consideration by commission. Obviously, the filings had different takes on social cost of carbon, and we'll be doing some deliberation on that in a second. And then the final component was there were some edits by AAG Boudreaux on Friday the 13th that address the concept of incorporating by reference. Those were non-substantive edits, but they are edits for our consideration today. So those are the areas that we have before us. Would ask AAG Mercer to make sure that I got all of this right, number one, and then if she had anything further she desired to present on behalf of either the AG's office or staff.
Thank you very much, Mr. Chair, and good afternoon, folks. For the record, I'm AAG Lauren Mercer, representing staff in this rulemaking. The only thing I would add to what you just laid out, Mr. Chair, is just a little bit of additional explanation and a correction of the record on one point related to last week's hearing on December 11th. So during last week's hearing, the Commission had a discussion about Rule 1403 for geologic science wells and monitoring wells. At the time, I stated incorrectly that Rule 1403 required an alternative location analysis and cumulative impacts analysis for science and monitoring wells. And after deliberation, the Commission instructed staff to remove from Rule 1403 the requirements for an ALA, cumulative impact analysis, and Form 50B. After the hearing and making these revisions, staff determined that 1403 did not actually require an ALA or cumulative impact analysis. I apologize for giving the incorrect information during hearing. I was thinking of a previous iteration of the rule. So those two things that the commission asked to be removed were already not in the rule. So in preparing the revised rules that staff filed December 11th, we did two things on this point. First, it was in the rules themselves removing the requirement of a Form 50B from Rule 1403. And second, in the statement of basis and purpose, staff specified that Rule 1403 does not require an ALA or cumulative impact analysis, but that subsequent Class 6 development plans that seek to convert such a well will include analysis of the cumulative impacts of drilling the well. So that was, again, based on commissioner instructions. So that's just the one correction I wanted to make. And then, yes, also just wanted to emphasize that as Chair Robbins said, staff filed those further revisions to the rules on December 13th to correct errata and how the rules incorporate by reference various federal regulations and industry codes. Those edits were made after a final proofread by staff to ensure that the rules comply with the Colorado Administrative Procedure Act. That law sets forth very specific requirements for how rules may incorporate a code, standard, guideline, or rule by reference. So the December 13th revisions were really just to ensure compliance there. And as you said, Mr. Chair, they don't make any substantive changes to the rules. So just to be as clear as possible, in staff's view, the most up-to-date documents that are on the table for today are the December 11th statement of basis and purpose filed by staff and the December 13th rules filed by staff. So that's all I needed to say, Chair, but happy to answer any questions.
No, I appreciate that. So just to be crystal clear, we're operating in our discussion and deliberations on the 1211 SBP and the 1213 rules, which was the last generated rules that contain the errata incorporated by reference and also the other revisions from staff.
Yes.
Okay, that sounds great.
Thank you.
Commissioners, we have these documents now before us. We maybe can take it in order. That might be the easiest thing to do. So does anyone have questions with regard to the edits to 1403 around the non-requirements of an ALA, a cumulative impact analysis, or Rule 50B for scientific and monitoring wells? To start, I do not. I'm comfortable with the changes. Is anybody uncomfortable with the changes? Ask the reverse. Commissioner Messner.
Thank you, Mr. Chair. The question I have is with the 50B, which again, like the Form 2B, is a data collection tool that helps populate our cumulative impacts database. And under the current rules as drafted, we wouldn't be collecting any of that data. And so to me, that seems unfortunate because it is a useful tool. So I acknowledge that the rules as drafted did not include the cumulative impacts analysis or the alternative location analysis, but did include the 50B, I assume because there was some interest in collecting that data to continue to populate the CIDR database. And so it seems to me like that still makes sense as a useful tool, even in the situation where there is a science well that's being contemplated.
All right. That's a statement for the record. I remain comfortable in my thought process about it that ensuring that science and monitoring wells get a chance to get through sends the message and is correctly establishing that Colorado is more open for business on the CCS front. And in weighing that versus finding that data for the few scientific and monitoring wells, I'm comfortable with where that lands. But that's just another commissioner talking about it. Anybody else desire to weigh in? Are we comfortable then relieving the 1403 piece as drafted? All right, I will say silence is acquiescence, and we will leave 1403 as drafted. The second area was the slight edit to the Bruno area notice. Commissioner Ackerman, this was something that you had brought up. Are you comfortable with the way that this was drafted?
I am, and I appreciate staff in the AG's office working on that. Thank you.
Okay. The third area, and I'm going to save social costs for carbon for last because that's kind of the more weighty topic. The edits on the incorporation by references under the APA. Does anyone have concerns about those edits? Seeing none, we appreciate our diligence of the attorney generals in catching those things, and those will remain in place. And then the final element for discussion this morning is the issue on social cost of carbon. We have the edits proposed by staff, which remain the edits from the December 11th. And that was in a filing called Staff Proposed Edits to the Statement of Basis and Purpose, reflecting the joint CDPHE, CEO, and ECMC statement on the social cost of carbon. And then we obviously have a few filings from some of the parties taking different stances on that. To start the discussion, I'm comfortable with staff's edits. I think it accurately captures the information that we received from our sister agencies, the CDPHE and CEO. And so I would be comfortable in adopting the staff supported language around social cost of carbon. I am yet one commissioner. What do other folks think? Commissioner Oath?
Thanks, Mr. Chair. I too, I think that the staff's statement of basis and purpose is a really helpful way to capture kind of the way that I'm looking at this, which is, that by statute, we are directed to look at, net cumulative impacts, and as defined, that includes consideration of climate impacts. And so one way to look at climate impacts from a qualitative standpoint will be a number of things, and social cost of carbon may be one tool amongst other information to consider that. So I think that that language, I would be comfortable with it. I actually also think at this point that if there are concerns, I think just taking out that language altogether from the statement of basis and purpose could also reflect accurately the deliberation and the outcome, meaning that, really how climate comes into consideration of cumulative impacts, and particularly net adverse impacts for disproportionately impacted communities is already incorporated by statute. And, who knows what tools may or may not be available, and what we may learn about various tools about how to consider the impacts of climate in the future. I guess to sum it up, I am comfortable with the staff's proposed statement of basis and purpose language. In the alternative, I would also be comfortable with letting the statute speak for itself and removing the statement of basis and purpose language that we had originally requested about 2 weeks ago.
Thanks, Commissioner Oath. Appreciate those comments. Other commissioners desiring to weigh in on this final issue? Commissioner Messner?
I agree with Commissioner Oath's statements. It's along the same lines as I was thinking. I'm comfortable with the language as is. I think a lot of times when we look at the statement of basis and purpose, or rules in particular, we try not to get too specific about certain technologies or philosophies within the rules, but rather try to capture the concept itself. I do note that if you did just eliminate that section that identifies the social cost of carbon in the statement of basis and purpose, it still captures the intent of the commission, which, as I read it, says accordingly, Rule 1410D specifies that the commission will weigh the potential adverse and beneficial impacts to public health and the environment when applying a no net negative cumulative impact standard. The commission does not intend to weigh economic impact in this analysis, period. That could be the cleaner way of doing it, but if the commission decides that it wants to utilize the additional specificity that staff has recommended, then I mean, I don't have a problem with it, but I would acknowledge that it is a tool amongst many tools that should be utilized by operators in applications as they look to qualify and quantify the no negative adverse impact, cumulative impact that we're required to look at as by statute.
Thanks, Commissioner Messner. Other commissioners desiring to weigh in? Commissioner Ackerman?
Thank you, Mr. Chair. I don't really have anything to add. I just wanted to say that I concur. I think the basis and purpose statement as written aligns with my original thoughts on this issue when we began the debate, and I am supportive of it as written. I would be open to further discussion about letting the statute speak for itself, but I'm very comfortable with staff's proposal here.
Commissioner Cross, going to put you on the spotlight.
That's fine. Thank you, Mr. Chair, and thank you, my fellow commissioners, for your thoughts on this. I'm comfortable with the language as written. I'm also fine, and I think I'd probably prefer just removing the language. Again, I think that we as a commission should not put anything forward that says do not submit certain information. I think if applicants want to submit information one way or another, I think it's then up for us to analyze the information that is submitted and give it the appropriate weight under our legislative mandate. And so I'd be fine removing it if, to the extent that it suggests that information should not be provided. So that would be my preference, but I'm fine with the way that it is written.
So to the three commissioners who contemplate removal, is your stance based upon, as Commissioner Cross just put it, that sort of widens the scope and doesn't narrow the scope of information that could be provided? Is that how you process to get to removal? Commissioner Cross, I think that's what you just said, so I'm paraphrasing you.
It is. I just don't want to suggest to any applicants that they should be limited in what they provide. In the same way as some of what I mentioned during our prior deliberations, I'm not against economic information being provided, but I also recognize that statute specifically talks about public health and environmental issues being the consideration for no net negative impacts. And so understanding that we are limited in what we are supposed to address and consider in making our decisions, I just want to make sure that people aren't then thinking that we are saying do not submit something that they want to talk about or they want to provide as part of their application.
Commissioner Oath?
Thanks, Mr. Chair, and thanks, Commissioner Cross. I would say my thinking on this is a little bit different. So I think there's, for me anyhow, there are kind of two separate issues here. One is in considering whether or not there is a net adverse cumulative impact. I think there was the question of whether or not economic considerations is part of that. And I remain comfortable that we should stay consistent with this statute and the language that we tweaked in the reg to say that in making that analysis, we will consider impacts to public health and the environment. For me, this question about social cost of carbon remains consistent with that as we think about impacts to public health and the environment and how cumulative impacts are defined. One of the factors of that is considering impacts to climate, so benefits or costs that come from impacts to climate. And so in doing this qualitative assessment of cumulative impacts as a whole, and climate being one element of that, I think that as I'm looking at this, there may be many different tools to consider cumulative impacts, and maybe many different tools for considering climate impacts as part of cumulative impacts. Social cost of carbon may be one of those. So I'm getting there by saying, wanting to leave the door open for whatever those tools are. I think if we say nothing in the statement of basis and purpose, that is what the that will be consistent with what the statute is telling us, that we can use whatever is appropriate in order to consider impacts to climate as part of our cumulative impacts analysis and net adverse cumulative impact analysis.
Thank you for the explanation. Commissioner Ray?
Thank you, Chair Robinson. Thank you, Commissioners, for all of your thoughts. As a non-voting representative of the DNR, I just wanted to share that in reviewing the materials that were provided by our sister agencies as well as the other parties, my sense is that there is some value in allowing the Commission to consider the social cost of carbon as one of many ways to assess the public health and environmental impacts of these projects. And so, again, as a non-voting member, I think the staff's proposed SVP changes articulate that value and I think have some benefit.
Appreciate that. And I think that's where I was kind of coming down, is that I think our sister agencies would prefer the language that they worked up with staff as opposed to going down this different path. I don't think I've heard a ton of displeasure from commissioners if we just go with staff's language. And if indeed that is correlative with where the sister agencies desire us to be, that would be at least this commissioner's preferred place to land. And appreciate the thoughts on that front, Commissioner Ray. Everybody comfortable with that, knowing that we're just getting this genie started, and we're going to be coming back and looking at these matters in the future, I believe, and we made a record of that. Okay, staff's preferred language going once, twice, 3 times, ding. Okay, so having gotten through that issue, we now have, I believe, and AG Mercer, if you could show up, the the December 13th version, the clean version, that would be consistent with the direction that we just went over in these 4 areas. Is that accurate? You're muted.
Can you hear me now?
Yep.
Yes, as to the rules, the December 13th clean version is the version that it sounds like you're proposing to adopt.
And then as to the SBP, it's the December 11th version.
It would be the December 11th version with the one edit to the social cost of carbon proposed in staff's filing also on December 11th.
All right. Those are the operative documents for a motion. Does anybody desire to further deliberate and or make a motion?
I would be happy to make a motion for approval consistent with what was just laid out between the chair and the AAG Mercer.
We have a motion. Do we have a second?
Second.
Motion and a second. Is there further deliberation or discussion on the motion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Any opposed? The motion carries. And with that, docket 241-000-246, the Class 6 rulemaking rules and SVP are approved. I have one other matter on that is not on the agenda that I wanted to bring to the attention of commissioners and stakeholders. Is there anybody desiring to further talk about the Class 6 rulemaking? All right, with that being done, I've been informed by staff that the first OGDP that is associated with the Lowry Ranch Comprehensive Area Plan is going to get to completeness this next week. That is the Lowry State La Plata South OGDP. Once it gets to completeness, notice goes out to stakeholders that it is complete, and stakeholders then have the opportunity to provide comment and/or ask for a Rule 511 hearing. I would suggest that we, the commission, go ahead and order up a 511 hearing so that we can make sure that gets done timely and not like wait on when it is most likely going to happen anyway because of the amount of interest in the Lowry Ranch OGDPs. I would suggest that we're probably going to have 511 hearings on each of these, and let's just go ahead and proactively do it. I would also suggest that we allow one commissioner to serve as hearing officer for the 511 hearings, and that we audio tape the hearings so that the other commissioners can listen. I would suggest to our stakeholders that a 511 hearing is a time for stakeholders to provide us comment, and we're not asking questions anyway. This is an expedited manner for us to process through the Lowry Ranch CAP OGDPs. It gives the stakeholders the opportunity to know there's going to be a 511 hearing. It doesn't require all the commissioners to venture out to the Arapahoe County Fairgrounds every single time, but it accomplishes the goal of the 511 hearing. So I would move that we approve a 511 hearing for the Lowry State La Plata South OGDP at such time that's consistent with the other rules and our process, et cetera. And I would nominate Commissioner Cross to be the hearing officer attendee at that hearing. I would ask the staff to make sure that we get an audio tape of it and then we all listen in. Of course, if other commissioners desire to go out, you can. So those are my thoughts on that matter. I know I'm catching you guys all cold on this, but I wanted to get it out ahead of the completeness determination and notices going out, because if this is the direction that a majority of us are comfortable going, I just wanted to make a record of it ahead of time. So any concern with that plan of action on behalf of the commission? Commissioner Cross?
Thank you, Mr. Chair. And I'm happy to kind of lead the first 511 hearing if we do numerous of these. I'll just say that I'm perfectly fine with the 511 hearing process. I'm always encourage local input, and especially going out to the community to get that input. So I'm in favor of having 511 hearings. And I do think that this is a good way to avoid future issues like we had with the Draco, where we have potential delays in hearing applications, and kind of get out ahead of it.
Great. Thanks for that. And thanks for the acceptance of the voluntold. With that, I move what I said. Do we have a second?
Second.
Motion and a second. Discussion on the motion? Seeing none, all those in favor of the motion signify by saying aye. Aye.
Aye.
All right. Motion, any opposed? Motion carries. And for the record, I did reach out to AG Davenport, and his legal advice was we could do all the things we just did. No problem. Commissioners, we are ready to, AG Davenport, do you want to just confirm what I said you said?
Confirmed.
Thanks. All right, commissioners, we are ready to adjourn for calendar year 2024. So moved.
Second.
Everybody have great, or let's vote on the motion. All those in favor?
Aye.
Aye. Wishing everybody the sincere best over the holiday season. See you in a bit.
Take care.